Assalamualaikum and hello. We are from Group 9 and we are going to present about the extension of port state jurisdiction over the incident that occurs in the high seas. First and foremost, my friend Fairuz Shahira binti Zulkifli, matric number 056486 will start presenting.
The term of high sea is not defined in the unit clause due to the two contradicting views which are EAZ, which is exclusive economic zone. In Article 86 of unit clause, state that the provision of the part apply to all parts of the sea that are not included in the EEZ, which is exclusive economic zone in the territorial sea or in the internal water of the state. Okay, then a port is a place on the coast at which ships can shelter or dock to load and unload cargo or passenger. And then a port usually has a city nearby so that merchants from all over the world can do business and trades. Okay, next I'm going to talk about the port state. Okay, the port state can be defined as any state with an international port and an inspection regime for nations to investigate foreign registered ships in port aside from the one of the flag state and state movement in opposition to ships that are not in compliance. Okay, then the port contains also have its jurisdiction, which is to exercise prescriptive laws, that is legislative and enforcement jurisdiction over foreign vessel inside their ports. Then apart from that, jurisdiction guidelines and requirement itself gradually moving from a voluntary foundation concerning confined subject area towards being comprehensive and obligatory through local and international arrangement.
Assalamualaikum. My name is Siti Noasha binti Siddiq. My metric number is 056655 and today I will be presenting extraterritorial jurisdiction. There are two kinds of jurisdiction. The first one is territorial jurisdiction and extraterritorial jurisdiction. Extraterritorial jurisdiction are states that have extraterritorial jurisdiction in some circumstances. Countries can claim extraterritorial jurisdiction concurrent with the flag state jurisdiction over crimes that happen on foreign flagged ships. Port state jurisdiction. Port state jurisdiction have been used for suppressing inadequate enforcement on the high seas due to the lack of agreement at international level. Port state plays a role as a first point of contact for industry engaged in activities that could be a harm to the global commons such as fishing and shipping. Port states have the right to oppose entry to visiting vessels, carry out inspections, and place conditions for such entries, possibly institute proceedings against visiting vessels suspected of breaches. Foreign flagged vessels indeed have no right of entry and they need to comply with the port state law. Port states have residual territorial jurisdiction under customary international law. International agreements have increasingly declared the existence of such residual jurisdiction, like international agreements on fishing are both binding and not binding. Exceptional crimes such as assault, manslaughter, or murder are said to be the interests of the port state. Finally, a port state's jurisdiction to manage foreign ships may depend on the choice of procedures to impose the needed requirement.
Assalamualaikum warahmatullahi wabarakatuh. For subject matter jurisdiction, introduction, jurisdiction means the ability of a country to make and enforce their laws. There are two basic types of jurisdiction. First, prescriptive jurisdiction and enforcement jurisdiction. If a person committing a crime either as an alleged perpetrator or a victim, their citizenship and jurisdiction to prosecute them are recognized under international law. Under UNCLO's central to the dispute settlement system established in Part 15 is Article 286, which acts as a compromissory clause. In conclusion, every country in this world has its own rules and regulation. A criminal act committed on board will usually lead to potential competing jurisdictional claim. This is where subject matter jurisdiction came to take place and helped to resolve a dispute between parties. Thank you.
Zero, and I will talk about the high seas. According to Article 87, it is open to all states where freedom of the high seas is exercised under the conditions laid down by this convention and by other rules of international law and comprises inter alia for both coastal and landlocked states. The basic principle governing the high seas, mainly about the usage of it, are thoroughly based on the customary international law. The two general conventions are the Geneva Convention on the High Seas and the United Nations Convention on Law of the Sea. Article 1 of the Geneva Convention on the High Seas stated that a high sea is when all parts of the sea that are not included in the territorial sea or in the internal waters of a state, and it consists of water column from outer limits of territorial seas of states, airspace superadjacent to uh, all of above and subjacent seabed and subsoil outside the continental shelves of the coastal state. Next, jurisdiction over vessels on the high seas. It is stated that ships will sail under the flag of only one state and, save in exceptional cases explicitly provided for in international treaties or according to these articles to its exclusive jurisdiction on the high seas. The provision stated that a ship may not change its flag during a voyage or while in port of call, save in the case of real transfer of ownership or change of registry. Next, ships which sail under the flag of two or more states using them according to convenience may not claim any of the nationalities in question with respect to any other states and may be assimilated to a ship without nationality. However, this right is not absolute but subject to some exceptions where third states share jurisdiction with flag state according to Article 99 until Article 110 of the UNCLOS. The exceptions pertain to crimes that are committed at sea.
Okay, next, for instance, to our issue, I will give example of the piracy. Okay, piracy is the practice of robbery or criminal violence by ship or boat born attackers upon any delivery or a coastal state. Okay, on the other words, piracy also can be described as any robbery or different violent action. The personal ends or without authorization with the aid of using public authority. Okay. Then, those who have interaction in acts of piracy are called pirates, whilst devoted ships which can utilized by them are called pirate ships. The earliest document times of piracy had been within inside the 14th century, while the sea people, a collection of ocean people, attacked the ship of the Aegean and Mediterranean civilization.
Next, for drug trafficking, the United Nations Convention prepare relevant forces that are related to drug trafficking, which are first 1961 Single Convention on Narcotic Drugs, 1971 Convention on Psychotropic Substances, and 1988 United Nations Convention against illicit traffic in narcotic drugs and psychotropic substances. The need to strengthen an assertion of prescription jurisdiction and process more foreseeable legislation regarding drug trafficking on the high seas was raised in the case of Medvedev against France. In this case, the court found a violation of Article 5, Clause 1 of the ECHR on the part of France on the basis that the pertinent provision of international and national law were not adequately precise, and therefore the detentions were not prescribed by law within the meaning of the above article. Article 70 of the 1988 Drug Convention mainly focus on the provisions for procedure that enable state parties to enforce jurisdiction based on the consent flag state. Article 4 of the 1988 Drug Convention, it requires state parties to establish jurisdiction over any offences committed in their territory or on board their vessel. Despite precedent cases, for example, Article 6 of the 1988 SCA Convention, the 1988 Drug Convention fails to require that states establish jurisdiction over offences committed by their national. Stated in Article 17, Clause 3 of the 1988 Drug Convention, committed on board a vessel in respect of which the state has been authorized to take appropriate measure.
Marine pollution. In the most recent efforts to control marine pollution are embodied in the draft of Convention on the Law of the Sea Section 90. According to the case Ernest Hemingway, Ernest Hemingway collided with a Korean fishing boat. The boat sank and about 600 liters of fuel oil spilled into the sea. The Busan District Prosecutor's Office were arrested, and MV Hemingway's second officer and seamen were prosecuted for professional negligence that has resulted in the violation of the Marine Environment Management Act and ship sinking. Busan District Court pleaded guilty and sentences were dismissed due to the lack of jurisdiction based on the UN Conference Law of the Sea Section 90. This is because South Korea is eligible to file a lawsuit on the MV Hemingway's case, and the verdict of the South Korean court is considered to be valid because the flag state did not file a lawsuit within the 6-month period. Thank you.
The next exception is about hot pursuit and constructive presence, where it allows warships or military aircrafts of a state to pursue a foreign ship that breaches the state's law, and the pursuit will have to begin while the ship violates the law is inside the territorial sea of the state. The breach of coastal state law and the good reason to believe must be justified in order for hot pursuit to take place. Article 111 Clause 1 of the UNCLOS states that in part, the coastal state must have good reason to believe that the ship has violated the laws and regulations of the state. Next, the article also needs the coastal state to have good reason to believe that its law has been violated, and they need more than just suspicion, but that it need not amount to actual knowledge. An example would be the MV Saga case, where the case is about an oil tanker flying the flag of St. Vincent and the Grenadines. Based on the evidence provided, the court held that the Guinean authorities just had suspicions that their law have been violated. Thus, this was less than the good reason to believe standard required, and the Guinean authorities had to release the MV Saiga and the crew members that were detained. There are 5 requirements for hot pursuit. Number 1, the type of craft may be employed to hot pursuit. Second, the pursuit must be immediate and given a signal to stop. Thirdly, after a visual or signal to stop at a distance which can be heard by the foreign ship. Fourthly, the pursuit must be continuous, and lastly, the pursuit must be in relay and multilateral hot pursuit. An example would be the I'm Alone case, where it is about a Canadian ship smuggling into the inland sea of the state. The authorities tried signaling them to stop, but they ran into the high seas. Therefore, the USA started their hot pursuit and fired the I Am Alone ship, and it sank. The court held the judgment on behalf of Canada because the USA had the right to hot pursuit, but it must be continuous in nature, making the decision to open fire towards the ship not legal. So, in conclusion, the port state's jurisdiction over the incident that occurs on the high seas has its own limitation in order to keep the balance of the states from fighting over power and wreaking havoc across the seas. These exceptions that are codified over the high seas exist, and it only extends to a degree where it is very rigid to make just to make sure that the crimes will not prevail and to serve justice. With that, thank you.